Good afternoon and happy St. Patrick's Day to everyone. Welcome to the Health and Government Operations Committee. We'd ask that if you received a Zoom link for this hearing, you do not share that link. We would ask you to encourage your friends to watch the hearing on YouTube. In terms of the timing of for the hearings, the bill sponsor or designee is allotted 5 minutes to present the bill. 5 witnesses will each be allowed to speak for 2 witnesses in support after the sponsor. If the sponsor doesn't use all of his or her time, that time can be delegated to one of the witnesses by the sponsor. Please stay in the hearing after you've spoken until the delegates have had an opportunity to ask questions. After that, up to 5 witnesses will each be allowed to speak for 2 minutes in opposition, and then please stay in the hearing to answer questions from the delegates. Please conclude your remarks when you see the timer finish. Members, please remember to remain present with your video camera on during the entirety of the meeting. And members, I'm going to remind you about our rules for questions. Only make your question shorter than the answer, please. Ask only one question of one witness. So witnesses, we ask that one person respond to the question. Sponsor, if you think that there is a person who is best suited to answer that question, please designate it when you're there. And if you have further questions, delegates, you know that you can follow up with any of the witnesses. Please use the raised hand function to indicate that you have a question. With that, we will start the meeting with HB 1302, Delegate Smith. This is Minority Business Enterprises Calculation of Participation Rates. Exemption for procurements for Maryland Correctional Enterprises repeal. Delegate Smith, welcome.
Good afternoon, and thank you, Delegate Cullison. I want to also say thank you to my colleagues here in the Health and Government Operations Committee. I'm honored to speak with you today in support of House Bill 1302. So what this bill seeks to do is repeal what is, in my estimation, an unjust exemption to minority business enterprises law by amending the State Finance and Procurement Code. Current MBE law requires state agencies to make every effort to achieve an overall minimum goal of 29% of the total dollar value of their procurement contracts, directly or indirectly from certified MBE firms. However, state procurement units are permitted to exclude the total dollar value of procurement contracts with Maryland Correctional Enterprises, also referred to as MCE, when calculating their MBE goal. MCE, the state's legally mandated preferred provider, is a prison labor organization that pays their laborers as little as 17 cents per hour. House Bill 1302 would require the inclusion of MCE contracts in these calculations. The MBE program was created to provide equitable opportunities for minority-owned businesses. Decades of discrimination that resulted in certain groups being socially and economically disadvantaged. Unfortunately, the disparity study conducted prior to the most recent reauthorization of Maryland's MBE program found ongoing, large, and statistically significant disparities in the use of MBEs by the state compared to their availability in the marketplace. For example, African-American owned construction businesses were paid just 5.1% of state construction contract dollars, despite making up 10.3% of the construction sector. Similarly, non-minority women-owned construction businesses were paid just 7.5% of state construction contract dollars, despite making up 13.7% of the construction sector. So those are just 2 examples. Relevant to this discussion is the long and painful history of the American criminal justice system, a system that has victimized and imprisoned generations of minorities and exploited prison labor to rake in untold profits. And exploitation, unfortunately, continues to this day. And that's where we're at with a bit of a sick irony in the system. This a commitment to ensuring opportunity for minority-owned businesses through its MBE program, but then it designates MCE as its preferred provider, and then additionally exempts any MCE contracts from counting towards the overall MBE goal. So finally, minority-owned businesses have been disproportionately impacted by the pandemic as compared to other non-minority-owned businesses. They have faced higher rates of closures. They have received sharper declines in cash balances, and also notably have received much more difficulty accessing vital PPP funds. It is more important now than ever that Maryland reaffirm its commitment to ensuring equity for minority-owned businesses. However, we cannot do this if we continue to undercut our pledge to equitable patronage of minority-owned businesses with this unjust exemption. That's why, with the foregoing, I respectfully request a favorable report on House Bill 1302, and I thank everyone for their time today.
Thank you, Delegate. So we're going to call a panel of favorable, and then after the panel is complete, we'll ask the committee to ask questions. So I'd like to invite Robert Dashiell to speak.
Good afternoon, Madam Chair, again.
Yeah.
And I'm happy to join Delegate Smith in supporting this rather simple bill, because it's intended to do just one thing, and that is not to reduce the state's preference for Maryland Correctional Services or for the blind industries or even for any of the other organizations that the state supports, but simply to stop the practice of crediting the dollar value of contracts with those other organizations, stop the practice of crediting the dollar value of those contracts towards the goals that are set for minority business participation. As Delegate Smith so articulately stated, those goals were established from a very arduous process, beginning with a disparity study to determine the availability of the businesses in the marketplace. And of course, the definition of a minority business is one that's owned by socially and economically disadvantaged people, which means that, and that requires that the social economic disadvantage result from a history of racial discrimination. So that the bill is not intended to take away anything from Maryland Correctional Services or to modify the law as it relates to utilization of their goods or services. It's simply to limit the credit that agencies take for minority business participation to the contracts that are actually awarded to minority businesses, as was originally intended. Thank you.
Oh, thank you, Mr. Dashiell. I'd like to invite Darlene Mitchell to speak, please.
Good afternoon. Thank you so much for this opportunity. I am Darlene Mitchell, an executive with Sage Services Group, LLC, a small woman-owned business minority firm based in Bowie, Maryland. And I ask for your indulgence for the next 2 minutes. I am in favor to repeal HB 1302. I am compelled to remind you of the following pivotal events. New York City, 1863, East St. Louis, Missouri, 1917, the Red Summer, 1919, Chicago, Illinois, Washington, D.C., Knoxville, Tennessee, Black Wall Street, Tulsa, Oklahoma, 1921, Rosewood, Florida, 1923. These dates are a chronology of the horrific and repeated slaughtering of Black business owners in Black communities. The attacks were perpetrated by angry white men, each time simply because Blacks were independently prospering economically and whites were not. It is astonishing that House Bill 1302 even has breath. The history of supplier diversity for minority businesses in this country is rooted in the civil rights movement of the 1950s and 60s. The state of Maryland has been a champion of minority business enterprise programs since its inception in 1978, when the General Assembly enacted its legislation, creating the program to ensure that socially and economically disadvantaged small business owners are included in the state's procurement and contracting opportunities. Maryland often leads the country in achieving MBE committed funding for dedicated staff positions to specifically and closely monitor the efforts of all state agencies to ensure these goals are met and maintained. Minority-owned businesses contribute $400 billion to the nation's economy and over 2.2 million jobs. Mega corporations such as Walmart alone spends $1 billion annually with minority and women-owned businesses. Coca-Cola is spending over $800 million annually on diverse businesses and have a goal of increasing that to $1 billion by the end of last year. These programs work. Inclusive procurement delivers broader societal benefits by generating economic opportunity for disadvantaged communities to affluent communities and everyone in between. The U.S. has committed a lot of wrongs in the past, denying access to opportunities to talented people because of the color of our skin. I ask, why is it each time Black and brown people are on the brink of taking our slice of the pie, a new legislation suddenly appears? And the course of the legislation always seems to minimize, reduce, retract, deduct, and dismiss what Black and brown people have rightfully earned. Of
Ms.
what
Mitchell,
character,
I need to ask you to wrap up.
of what character is a man who will put his child under tremendous training for years to reach the Olympics, then when of age, tell him he's only qualified to join a community league in a town with no team? May I suggest taking advantage of this opportunity to create a new category for participation goals for MCE, which is also a worthy and deserving entity. Thank you.
Thank you. Questions for this panel, for the sponsor or her panel? You please use the raise hand function. Delegate Lewis.
Thank you, Madam Chair. Thank you, Delegate Smith, for bringing this really important bill. I'm glad you figured out a way to help the state increase its minority, its MBE, actually achieve its MBE goals. So yeah, this is something that a lot of us care much about. Thank you. I was just wondering, I want to make sure how this works. The Maryland Correctional Enterprise currently uses prison labor to produce materials, objects for sale, for retail. If this bill were to pass, what would happen to the laborers who are incarcerated and the work that they do? Would there be any change, any impact on them?
Thank you, Delegate Lewis, for that question, because it's an important one. I want to also refer your committee to the fiscal note that mentions that what this bill does not materially actually change MCE's operations, so to speak. They'd still be a preferred provider of a host of things, including the very desks many of us are sitting at, right now, produced by MCE. All this does is remove the MCE kind of contracts, or rather includes them in the actual overall procurement portfolio. Because right now we had this goal of 29%, but if we exclude the contracts we have with MCE from that portfolio, then we actually don't have an accurate portrayal of the total percentage of our, our vending contracts, what it looks like. And many ways, exempting them makes it appear that we're doing more business with MBEs than we really are. So if we want to have like an accurate sense of business dealings of the state and who we're contracting with, we think it's appropriate to repeal that exemption, include them in that procurement portfolio, and then see, are we still reaching 29% with the full kind of spread of contracts that we're making as a state across our various agencies. So the fiscal note notes that it really doesn't change MCE's bottom line, but it could create more opportunities for MBEs that currently aren't maybe being thought of for the other non-MCE related, preference.
Right, so it could sort of stimulate the state to make additional effort. Thank you so much. And I'd like also Delegate Smith to thank your panelists, Ms. Mitchell and Mr. Daschle, for their compelling testimony. Thank you, Madam Chair.
Thank you, Delegate. Seeing no further questions, that completes the hearing on HB 1302. Thank you to the delegate and the panelists for their time and testimony today. And we will move to the second bill of the day, which is House Bill 1323, Delegate Hill, Algorithmic Decision Systems, Procurement, and Discriminatory Acts. Delegate Hill.
Thank you, Madam Chair, and thank you, Madam Vice Chair and committee members. I would ask that you repeat that title 5 times fast, just to get the tongue moving a little bit. So what is this bill? What is the problem we're trying to fix? So we all know, loosely what an algorithm is. An algorithm is a sort of a system, whether computer generated or written down, sometimes uses computations, but it's a process that we go through to come to certain things. And when we use algorithms in decision making, we sort of automate the process of coming to our decisions. So for instance, we use algorithms in healthcare to determine what particular, what a patient's workup should be, whether they should get certain kinds of films or not films. We use algorithms in criminal justice when we make determinations about who is considered a good risk to put out on parole, or who is considered a poor risk for diversion into, out of the criminal justice system into the behavioral health rehabilitation system. So we use algorithms all the time. And the other reality is that, policy matters. And when we have policies and processes that are either, blind to the potential damage they may cause, or are complicit in causing damage, we should not be surprised when it turns out that we're causing damage. So we've spent a great deal of time, this committee and this General Assembly in the past several years, trying to undo past damage that has been caused by poorly thought out or misguided policy. But what we haven't done is very much to be proactive in trying to make sure that we don't put into place future policies and future practices that are going to cause harm down the way. What this bill says is that when we're putting in automated systems, whether it's in healthcare, whether it's in our criminal justice system, whether it's in our economic system or the environment, that we're going to be thoughtful, that we're going to make sure in advance or as sure as we can be that the algorithms that we put into place to achieve certain goals aren't undermining our state values and the goals we've already set. That's simply what the bill does. There was an earlier version of the bill that really required that before an algorithm went into place, that it was vetted to make sure that it didn't have bias inherent in it that would undo the goals of the state or the goals of the program. The problem was that that wasn't really actionable, because although there are a lot of groups that are looking at what's called responsible AI, responsible artificial intelligence, because they recognize how powerful this tool can be for good or for evil, there really was no defined, universally accepted way to vet. And so this procurement model is how the bill came in consultation with artificial intelligence and algorithmic experts. Chair of the Information Systems Department at UMBC, Dr. Vandana Janaji will be on the panel. So this is a way that we can get at it. And I think it's really something that we need to be doing. It's proactive. And we need to be more proactive and spend a little bit less time playing whack-a-mole at the back end. And with that, I will reserve the last 50 seconds for the panel.
Thank you, Delegate. I'd like to invite James Bolts to testify.
Thank you for this opportunity to speak. I'm James Folds. I'm an assistant professor in the Information Systems Department at UMBC, and my research focuses on fairness and bias in artificial intelligence and machine learning systems, and I have multiple federal grants and research publications on this topic. I am pleased to testify in support of House Bill 1323. AI and data-driven systems are currently being used by the state of Maryland for decision-making in areas including criminal justice, law enforcement, and healthcare. These systems are valuable as they can potentially lead to better, more reliable, and more just decisions. However, fair and equitable behavior of algorithmic decision systems is far from guaranteed. A growing body of research, including my own work, has shown that biases can enter these systems at every stage of the development process. Impacted individuals often have no recourse on how to correct these decisions, which can be life-altering. So the antidote to algorithmic bias is as simple as ensuring that data ethics, fairness, and transparency are given appropriate consideration in the design of algorithmic decision systems. House Bill 1323 provides sensible and reasonable requirements which will hold the software vendors accountable. It will help to ensure that responsible AI best practices will protect Maryland citizens and advance the state's efforts to be inclusive and fair. For more information, please see the written testimony in support of this bill submitted by Dr. Vajna Juneja, to which I also contributed. Thank you for your favorable consideration of House Bill 1323.
Thank you, Mr. Folds. Vandana Janata.
She submitted the written testimony that and Professor Foltz just spoke to. They did the written testimony together, and he represented the two of them, and we'll be here to answer questions.
Thank you, Delegate. Okay, so are there questions of the sponsor and her panel? Delegate Rosenberg, is your real hand up?
Trying to maneuver.
There we go.
Isn't this in a neutral way? What standards are there? Existing standards for that would cover the scope of what you're seeking to do, both in terms of discriminatory acts and the other aspects of this bill.
So
not that we shouldn't be
trailblazers,
but yes.
Yeah, I'm going to ask. So, and we've included as many as we could find in the bill. There are multiple aspects to determine that. Professor, could you go into some of the detail of what makes responsible AI?
So standards are emerging, but the best source for reputable standards is the standards organizations such as the ACM, Association of Computing Machinery, and IEEE, which is the Engineers Society. They put out these various standards and best practices. So I would refer to them. There's also emerging guidelines from industry leaders such as Accenture have put out various guidelines on best practices. So there is not one authority, but there are many and a growing body of them which can be referred to determine what are the best practices.
Thank you.
Thank you. Delegate Lewis.
Thank you, Madam Chair. Thank you, Delegate Hill, for this interesting bill. Whoever is best positioned to answer this question. So we know, it's well established, that publicly available search tools like Google have baked in bias in their search. So for example, I was trying to do a Facebook post about little kids playing outside, and I did a search for little kids playing outside, and there were only white children in a suburban setting. And if I put in Black children playing outside, I didn't get images that I wanted to use. Would your bill affect my experience in doing search here in Maryland?
Thank you very much for that question, Delegate. This bill would affect how the state does its AI. So it might not affect your public search, but it would very much make sure that in an analogous situation where the state, let's say, was doing a procurement and looking to identify, different companies, that the standards that were put into the algorithm to determine what would be an acceptable company to do business with would be less likely to incorporate into the algorithm biases that may be unrecognized by the designer of the algorithm, but reflect their life experience instead of a broader life experience. If I may give an example and go a little bit further. We know, and you talked about the particular search, we know that if someone is writing an algorithm that looks for people who we want to put in executive positions, right? If I look for executive, I might have someone who writes an algorithm that says, I want people who are, scout leaders, who've been captains of sports teams and have done military service. And that is an example of someone I want to be a leader in my community. There may be someone else whose life experience says that I want someone who has worked from an early age, had to be independent, overcome a great deal of adversity, and because that's a life experience that I want to see. If those two folks are at the table, we might actually have an algorithm that is inclusive. But if either one of them is solely responsible for writing it, then just by the nature that they only have their experience to go by, we're going to have an algorithm that is biased. And what the state does with that will reinforce or create, either reinforce old biases or it will create new ones. So that's what we're trying to adjust. So it won't affect the public search, but it will affect how the state does and what kind of damage we mitigate proactively.
Thank you. I still don't feel like I'm understanding. And Madam Chair, may I ask a follow-on question?
I'm going to ask you to follow up with Delegate Hill offline just because we're on a shortened time frame today.
Oh, that's right. Thank you so much, Madam Chair. Thank you.
Thank you, Delegate, for understanding. Are there any other questions from the committee? Seeing none, I'm going to call on a panel of unfavorable, and that is Ms. Pam Casemeyer.
Hello, members of the committee. This is Pam Casemeyer, and I'm here on behalf of the Maryland Tech Council. First and foremost, I'd like to say the Tech Council is not here in opposition because of the objectives or intent of this bill. In fact, we applaud the delegate for wanting to work on this because the Tech Council itself and its member companies believe that further revision of these algorithmic decision-making systems and things that we're intending to be sure are not biased is a good objective. And in fact, I think the Tech Council would say it would look forward to working with UMBC and others as this goes forward. But I guess I would call your attention to be very brief. Dr. Folds himself said these are emerging standards. This is an emerging area of evaluation and an emerging area of refinement. I'm not techy, you can tell, but these standards are being developed. They're being established. The ability to adequately evaluate whether or not there's bias is an emerging area. And we would say that on behalf of the Tech Council, putting in place and at this time is jumping ahead of where we are, where we would be comfortable that the state could actually adequately make these evaluations. And then when you add in the provisions that say it could be subject to civil actions by the Civil Rights Commission, it becomes very concerning and almost puts a squash or almost stops the desire for companies to continue to try to develop and refine these out of fear they're going to be viewed as discriminatory, even as their goal is to not be moving forward. So we feel like it's a great issue. We're just a little ahead of ourselves and looking for this.
Thank you, Ms. Casemeyer. Any questions from the committee? You'll have a chance to put your hand up while I ask a question. So if I understood correctly, so the Tech Council appreciates the intent of the bill and understands, you know, trying to achieve, and that there's probably room for these kinds of changes as we go forward. I'm just wondering if the Tech Council can play a role in helping to define how we might achieve the intent of the delegates' bill, and are they ready to engage in it?
Yes, I think so. And in fact, many of these companies not probably, I mean, there's multiple companies that are members of the Tech Council, but there are members within the tech industry that are already working on these things. They're involved with artificial intelligence and algorithmic decision-making. These kinds of evaluations are part of what they're already doing. If I understand right, I think UMBC may be interested in setting up some kind of a platform or program or something to further look at this and develop it. And the Tech Council would want to be at the table because many of their members are already working in this area. It's emerging. So yes, I think there's no doubt that we're not here because we don't think these standards should be developed. It's just that they are in their development stages.
Okay, great, thank you. Delegate Hill.
Thank you, Madam Chair. And I usually don't ask questions on my own, but I wanted to be sure that Ms. Casemeyer had an opportunity to see the amendment that we've offered, much based on discussions we've had with the Tech Council, and would be willing. We've spoken with the folks from Amazon who actually are much more excited about the earlier version that we did not introduce because we thought that that was unactionable. But I'm hoping that the Tech Council would be willing to sit down with us even the next 24 hours, and the folks from UMBC and the Amazon folks, because if I'm understanding you correctly, are you saying that this is something we need to be proactive? The council is simply concerned that this bill may be prohibitive and you're not sure if the amendments get to the prohibitive issue? Is that what you're saying?
And I have not seen the amendments, so they have to look at them to be able to evaluate if they've changed the parameters. I think what they're saying is if you jump ahead too soon, you create disincentives for innovation in Maryland, solely in Maryland, even as the goal at which you're moving forward is a good one, because everyone gets nervous based on the bill as drafted that you've got standards in law that are considered discriminatory before the technology even catches up to being able to determine whether it's actually discriminatory or not. But I have not seen your amendments. I know this is an area that many of them are working on. But I don't have it, so.
Okay, thank you very much. Seeing no other hands in the panel, that concludes the hearing on 1323. Thank you, delegates. Thank you, panelists, for your time and testimony today. We'll move to the next bill, which is House Bill 1265, Delegate Fisher, State Government Notarial Acts, Remote Notarizations. Delegate Fisher, welcome.
Thank you, Madam Chair. Thank you to Chair Pendergrass and Vice Chair Payne-Melnick and the great members of the Health Government Operations Committee. It's so great to be with you all again. And I'm happy to introduce HB 1265, Notarial Acts, Remote Notarizations. This is a cross-filed and bipartisan bill. This bill authorizes remote notarial acts and clarifies the application of credential analysis and identity proofing in regard to doing remote notarization. HB 1265 clarifies that the documents are in conformance with our governor's executive orders that were issued during this COVID pandemic crisis and amends that order. It also deems valid through the duration of the executive order. This bill proposes codified language for automated software to aid notary republics in determining the validity of identification credentials. This bill also will increase the efficiency of administrative tasks and reduce acute difficulties that residents have been facing due to the COVID pandemic, and encourages consistency between jurisdictions in the acceptance of identification credentials as valid. This bill, I have sent the amendments for this bill to this committee that were worked on for our chamber and for the Senate. My Senator Crosswell is also worked on Senator West also worked on these amendments to conform. This bill has been a large effort of our estates and trusts section of the bar. And also you will find in your testimony a support letter for our Attorney General. I think you're going to hear from a great panel on the technicalities of this bill. I also think that this legislation is really helpful when it comes to access to services to those that are either homebound due to illness, to other economic issues, to receive legal services or services of a notary, which usually are in conjunction with legal services. I also wanted to flag for this committee that this bill was a part of a series of legislation. The other bills were in the House Judiciary Committee where I'm from. And those bills had to do a lot with, again, the digitalization of wills and trusts and estates, all that came out of the COVID pandemic that we've experienced, and folks in our community needing access to these legal services, but doing it within accordance to the law in a digital way. So this part of that pack, it's almost like a 3-bill package. This notary part, though, came here to Health and Government Operations for your consideration and support, just to give you the framework. So again, it's been a lot of effort to get all parties in agreement. And I'm very excited for you to hear from the panel, and I'm here for any questions. So thank you so much, Madam Chair.
Thank you, Delegate. I have 2 questions for you. Is there a particular panelist you'd like to devote your remaining time?
Yeah, I think Ms. Muffaletto would be great to go first if you would call on her.
And then the other question I have is, so I have 3 people signed up favorable with amendments. I'm assuming those are your amendments that they're speaking to?
Yes, Madam Chair. Okay. And I believe, thank you so much, Vice Chair Payne. Emailed me late. I emailed them to her, and I emailed it to the, I think the generic HGO email. So I hope it was obtained by the correct counsel for the committee.
Thank you. So then I'll call Ms. Muff for the first testimony, and you'll have the delegates' time as well as your own.
Great. Thank you very much, Madam Chair. I'm happy to have this extra minute. I always feel like I have to talk so fast. But thank you very much. I appreciate your time. Members of the committee, my name is Michaela Muffaletto. I'm the chair-elect of the Estate and Trust Law section for the MSBA. We're here today requesting a favorable report on House Bill 1265 with amendments. House Bill 1265 makes changes to the revised Uniform Law on Notarial Acts, also known as RULONA, which was enacted in 2019, but not made effective until October 1 of 2020. RULONA itself modernized how documents could be notarized in Maryland, and for the first time, documents were permitted to be notarized remotely. But when it was enacted, it specifically excluded wills and trusts, which have in particular during the COVID-19 pandemic, have impacted our estate and trust law section tremendously. House Bill 1265 will remedy that and removes this restriction. Under this bill, wills and trusts will be permitted to be notarized remotely, just like under the governor's executive orders that were issued at the beginning of the COVID-19 pandemic. The amendment to House Bill 1265 also authorizes the remote notarization of a tangible record. This will allow us to notarize documents remotely in ink as opposed to electronically, as was permissible under the governor's initial executive order, which authorized remote notarizations prior to RULONA's effective date on October 1. In addition, House Bill 1265 has a few clarifying provisions. with remote notarizations, there are requirements for credential analysis and identity proofing. These requirements are necessary to verify a person's identity, particularly when documents are notarized remotely, but they should only apply when the notary cannot identify the signer's identity through personal knowledge or through testimony of a credible witness. House Bill 1265 clarifies this and makes it clear that the requirements for those two items only apply when the signer's identity is not known or attested to by a credible witness. Finally, House Bill 1265 ratifies all remote notarizations that have been done under the executive orders. And because of the urgent need for this legislation, the amendment also changes the effective date from October 1 to June 1. So as Delegate Fisher said, the Estate and Trust Law section, in working with Delegate Fisher on this legislation, we worked with various stakeholders. We participated in a lot of meetings with members from the Uniform Law Commission, from the Secretary of State's office, from the Office of the Attorney General. We have a broad base of support from the Real Property section, the Elder Law and Disability Rights section of our bar, and we also have the support of the Office of the Attorney General. No opposition was anticipated or filed, and for these reasons, we would request a favorable report from the committee on House Bill 1265 with amendments.
Thank you, Ms. Maffoletto. Deb Howe?
Good afternoon, and thank you for your time. My name is Deb Howe, and I am an attorney practicing trust and estate law and a member of the Maryland State Bar Association Trusts and Estates section. And I'm asking this committee for a favorable report on House Bill 1265 with amendments. Ms. Maffoletto discussed the details of the bill and some of the specific things that it does. So I'm going to focus on the impact of allowing remote ink notarizations as the amended bill would do. The current procedure for remote notarizations, as interpreted by the Secretary of State, only allows for remote electronic notarizations. Many elderly, disabled, and immunocompromised individuals struggle with the technology involved in the remote electronic notarization. The bill, as amended, would allow them to sign a physical document while on a video conference with a notary, making remote notarizations available to the individuals who need them most. Delegate Fisher mentioned that this is truly an access to these services and access to justice issue for these individuals who struggle with the more complex technology involved in electronic signatures and notarizations. In addition to giving elderly, disabled, and immunocompromised individuals access to remote notarizations, Bill 1265 would also allow smaller law firms access to remote notarization services. The vendors that the Secretary of State has identified for remote electronic notarizations are quite costly, in some cases prohibitively so. They usually involve an annual fee for the platform in addition to a transaction fee. So the bill will assist individuals who need access to these remote notarization services, as well as smaller law firms that would otherwise be unable to offer those services. And it's for those reasons that I am asking for a favorable report. Thank you.
Thank you. William O'Connell.
Good afternoon. Thank you for having me. I'll cut to the chase. This bill is essentially clarifying what's already there. It makes it clear that you can do a remote notarization using paper instead of an electronic document. If you know the person, you don't have to do the identity proofing because you already know them. The code already provides a mechanism to determine whether you have sufficient knowledge of the person to complete the notarization process based on personal knowledge. This just makes it a little bit clearer for those who need it. It removes some carve-outs that we don't need, and it allows for the paper to be used. So right now, paper is not really spelled out in the code, but this makes it clear that you can use paper. If you don't know the person, You can still now use paper, but you're still going to have to do the identity proofing. So that's the safeguard. What we need also is to allow for the increase in the allowable charge for remote notarization. $4 is ridiculously low. All that does is prevent Marylanders from using a remote notary service from a Maryland notary, because with electronics, there are no borders. So it's just as easy for the Maryland consumer to call up a notary in Indiana who doesn't have that restriction, complete the notarization, and they're done. The only problem is that Indiana notary is not subject to Maryland regulation or Maryland law. So I ask that you give a favorable.
Thank you. Are there questions from the committee of the delegate or her panel? I see no questions. So, oops, Delegate Hill.
Sorry, I'm slow on that finger. I just wanted to ask the sponsor, there were several or a couple of amendments that were offered. Did she have any weigh in on, one was about fees and there are a couple other things. I didn't know if she had a thought about the amendments and if the subcommittee takes those amendments up.
Sorry, Madam Chair, I was talking and I was muted. Yes, I requested the amendments and I'm supportive of the legislation with amendments. And I know that the bill can be a little technical. So if you do have any questions, my panel, I'm sure, would be able to answer them offline as well. Ms. Maffaletto is just the expert and knows it in and out as well. So, but yes, I am favorable with the amendments and I believe most of them I drafted. So they should be mine.
Thank you.
Okay, thank you. Are there any other questions? Seeing none, that completes the hearing on House Bill 1265. And we thank the delegate and her panel for their time and testimony today. We will move to House Bill 1088. Delegate Acevedo, welcome, Delegate. I knew you're here someplace.
Yes, I'm here.
Non-discrimination and LGBTQ plus individuals. Delegate Acevedo.
Thank you very much, Madam Chair. Good to be back in HGO. For the record, Delegate Gabriel Acevedo here to present House Bill 1088, the Maryland Youth and Families Protection Act, which seeks to extend the prohibition of discrimination on the basis of sexual orientation and gender identity to Maryland's entire system of care to include child welfare services, juvenile justice, human services, contractors, grantees, and other programs and entities that receive state funding or public dollars. Colleagues, let me just say that this this piece of legislation that I'm submitting really is the unfinished work of LGBTQ plus protections. We know that over the years, we have done a lot of work to ensure that we protect LGBTQ plus Marylanders. And what this bill does is it ensures that our youth, particularly LGBTQ youth who are disproportionately in the foster care system, that they receive the kind of a care and support that they deserve, but also people who are competent in the way that they are dealing with or interacting with LGBTQ plus youth. House Bill 1088, and I think my panel will speak a little bit more to it, would allow for the training, would allow for the training that's necessary of state employees to ensure that we're interacting with LGBTQ plus youth in the way that we should. According to a 2016 report from Maryland's own the Youth Equality Alliance, it estimates that between 47,000 and 95,000 LGBTQ youths are in the foster care system. Apologies, at 47,000 to 95,000 LGBTQ plus youth in the state, there are between 47,000 and 95,000 LGBTQ plus youth in the state. And of that number, 90% of them have heard anti-LGBTQ language on a regular basis. LGBTQ youth are disproportionately more likely to enter the foster care system than their non-LGBTQ counterparts. Just some numbers, 30.4% of youth in foster care identify as LGBTQ plus, and 5% as transgender, compared to 11.2% and 1.7% respectively in the overall population. Colleagues, House Bill 1088 will make protections of LGBTQ youth explicit by expanding current non-discrimination law to include sexual orientation, gender identity, gender expression throughout Maryland Code. This is critical because it provides clarity for professionals regarding their obligations, and it is also an essential component of policy and training. There is a clear need for more comprehensive policies serving LGBTQ plus youth and families in foster care and juvenile justice, in addition to those who are experiencing homelessness. House Bill 1088, the Maryland Youth and Families Protection Act, would allow for the training necessary to serve our community with competence, to ensure that we're interacting respectfully with LGBTQ plus individuals, but especially our youth, and would do the unfinished work of protecting every member of our community and ensuring that the people that we work with, the people that we interface with, understand and are able to relate to us in a culturally competent manner. And so with that, colleagues, I thank you for your time, and I urge a favorable report from this committee. Thank you.
Thank you, Delegate. Is there someone on your panel you'd like to devote the rest of your time to?
Yeah, wow, all the speakers are amazing. Hard to say, Delegate, really hard to say, but yes, please, I'm happy to give my remainder of the time to the panel.
So, well, I'm gonna call Tina Dove then. Tina?
Good afternoon, Madam Chair, members of the committee. My name is Tina Dove. I'm with the Maryland State Education Association, and I want to thank the delegate both for introducing this important piece of legislation and for affording me some extra time. Given the emotion that I'm feeling in this moment about this legislation, I think I might need it. As many of you know, today marks the feast day of St. Patrick's, who is the patron saint of Ireland, and so many people are celebrating, wearing their green, etc. But it is also a very important day in American history that many people may not be aware. And I would be remiss as a social studies teacher if I didn't share some social studies knowledge. On this day in 1912, one of our country's greatest heroes was born. He devoted his life to social movements for civil rights, civil liberties, and social movements. He devoted his life to equality before the law and elevating the voices of those in society who were rendered unworthy of a voice and fighting for the agency for those deemed unworthy of agency. His name was Bayard Rustin. I count him as an elder, as an ancestor, and as a voice for freedom, not just for me, but for my brothers and sisters who are members of the LGBTQ community. And while I am not an official member of the community, I consider myself to be a co-conspirator. And so I am proud to stand on behalf of the educators in our state in support, in very, very proud and robust support of this legislation. We believe that the treatment afforded to our ancestor Bayard Rustin was inappropriate then, and it is inappropriate now. Because he was born a gay man, he was maligned by his countrymen for being a pervert and being an immoral influence, simply because of who he loved. This, of course, came on top of the fact that he was deemed to be less than a citizen in his lifetime and deemed to be overall inferior because he was born a Black man. The laws of our country during his lifetime officially sanctioned this type of injustice against him. And while some things in the law have changed for the better, since his death in 1987, there are still laws in place or the absence of laws that would render him to be only slightly better today than he was then. And it cannot be questioned that that is unacceptable. It is unacceptable that his Black life didn't matter, and it is unacceptable that his life as a member of the queer community didn't matter either. That should no longer be standing in federal policy, and it most certainly should not be the status quo in state policy. HB 1080 would serve as a significant step toward our state reaching the more perfect union that is delineated in the preamble of our Constitution, a Constitution that our state Constitution in our Declaration of Rights deems to be the supreme law of the land. On behalf of the children that we serve, on behalf of my brothers and sisters in the queer community, I fervently ask for a favorable report on this legislation, and I thank the delegate for being a brave champion of that community and commit, members of MSEA, we commit to that fight to have your back and the back of the members of the queer community. Thank you for the time, and thank you, Madam Chair.
Thank you, Ms. Dove. Joseph Clapsaddle.
He won't be with us today.
Oh, he won't. Okay. Jeremy Lemaster.
Yes, hello everyone. Good afternoon. Thank you, committee, for inviting Free State Justice to speak here in favor of House Bill 1088. My name is Jeremy Lemaster. My pronouns are he and they. I'm a Baltimore resident, and I have the honor of serving as the executive director for Free State Justice, a 30-year-old LGBTQ legal services and advocacy organization for low-income, lesbian, gay, bisexual, and transgender folks in the state of Maryland. Our entry point into this work has been years in the making. We've spent a number of concerted, years with concerted effort to protect LGBT youth specifically in their interactions with foster care, as well as the juvenile justice system. Because as we know, over 78% of LGBTQ youth leave placements because of issues encountered related to their sexual or gender identity. And our legal team has encountered horror stories of the treatment of LGBTQ youth in juvenile justice system. We pursued administrative advocacy, collaborating and working with very well-intentioned allies and public servants to really strengthen Maryland state institutions to better serve folks, but it's really fallen short. I think most recently, DHS, we worked to implement a policy to really ensure that LGBTQ youth were placed in adequate housing with folks that were trained and able to care for them. However, DHS just last month in February had to revoke that policy because there was just not enough folks being trained on working with LGBTQ youth. And that has left a number of disproportionately sort of impacted LGBTQ youth vulnerable within our foster care system. This bill really, for us, is the floor. It should be the policy of this state that any public funding is non-discriminatory in nature, and that all of our folks sort of carrying out services in the name of the state are able to do that in the way that is serving all of Marylanders. And honestly, with that, that's really why I urge a favorable report for House Bill 1088.
Thank you very much. Legacy Fort.
After several emails, Ms. Fort is not with us today.
Okay. Rob Shear.
Thank you. Hi, my name is Rob Shear, and I'm the founder of a national nonprofit that tries to give hope and dignity to our youth that are in foster care. But the most important title, I'm a dad to 5 amazing kids. I'm a dad to 5 kids because of foster care. I was a kid who aged out of the system, and as a gay male, aging out of foster care was one of the scariest things because I became homeless. When I decided to be a dad, my husband and I immediately went to foster care. 12 years ago, our first 4 children arrived, and we knew it was going to be an uphill battle. 2 white gay men adopting 4 black kids. No one was looking at that with any type of glory. But I was surprised that 2 years ago, when we decided to have our 5th child, a child who was 18 years old and was going to age out of foster care, how we were treated and looked at, because again, we were 2 gay men. I remember calling the agency, wanting to give our 5th son some hope and some love and a forever family. But instead, once they found out that we were a same-sex couple, we never received a phone call back. We never received an email back, but we were determined to give our son Alex a future. And we're happy to say that within a matter of 2 months, we will actually actually sign our adoption papers for our son Alex. So we're in favor of this bill for equal rights for all, not only my LGBTQ brothers and sisters that are in foster care, but those of us who are trying to adopt kids out of foster care. So I ask that you please pass this bill. Thank you.
Thank you. Curry Cook. Curry Cook.
Yeah, hi. Sorry, I was having trouble getting off mute. Good afternoon, members of the committee. It's my pleasure to be here today to testify in favor of HB 1088. My name is Curry Cook. I am Senior Counsel and Director of the Youth and Out of Home Care Project at Lambda Legal, a national legal nonprofit dedicated to achieving full equality for LGBTQ people. I advocate for LGBTQ youth and families who are involved with government systems of care. I've represented children, including LGBTQ youth, in juvenile court for over 20 years and serve on the board of the National Association of Counsel for Children and the American Bar Association's Children's Rights Litigation Committee. HB 1088 adds explicit and holistic non-discrimination protections for LGBTQ youth and adults in the Maryland Code, filling gaps in the code to ensure that all Marylanders, especially those that are most vulnerable, may access government-funded services and programs equitably and safely. As Delegate Acevera mentioned, LGBTQ youth are overrepresented in government care. While representing about 5 to 10% of the general population, they're around 20 to 30% of kids in foster care, 20% of youth in the juvenile justice system, and a staggering 40 to 50% of youth experiencing homelessness, and they are at higher risk of trafficking. Due to societal inequities, these youth are disproportionately youth of color. The disparities and harm they face are, of course, no fault of young people themselves who are simply trying to be who they are. Too often, I've seen my clients harmed by systems that are there to help. LGBTQ adults too face disparities and harm. LGBTQ parents of color have their children removed at higher rates than their white non-LGBTQ peers. LGBTQ seniors disproportionately face housing discrimination and harassment while accessing care and food assistance. And LGBTQ people face challenges accessing the court system without fear of being harmed. Maryland should be applauded for the robust protections that do exist in law and some agency policies, but those protections do not exist across the code at all agencies. While professional standards are quite clear about how you should be treated, law and lived equality have lagged behind. HB 1088 fills those gaps, and HB 1088's training requirements ensure that practice conforms with these protections and that all staff and contractors are equipped to make sure that LGBTQ youth and adults are safe, treated equitably, and prevents costly outcomes like homelessness, institutionalization, and most significantly, harm to Marylanders. Thank you so much for your time, and I ask a favorable support on HB 1088. Thank you.
Thank you. Questions from the committee? Okay. Any questions? All right, see, you've made your case. Thank you very much, Delegate. Thank you all. Thank your panel for coming, for your time and testimony today. That concludes the hearing on 1088. And we will move to the next bill, which is House Bill 770. Delegate McIntosh. And this is Baltimore City Community College Procurement Authority. Is Delegate McIntosh?
I am here. Can you hear me?
Okay. Yes, we can. Thank you. Oh, there you are, Madam Chair. Thank you.
Good to see everyone. And thank you, Delegate Cullison. I want to thank also Chair Pendergrass and also the Vice Chair, Pena Melnick, for hearing this bill, and also all of you on the committee. I'm here today to present House Bill 770, which is entitled Baltimore City Community College Procurement Authority. I'm a former educator, as you know, and very pleased to present this bill. Have always been very much a supporter of the Baltimore City Community College. I need to be honest with you. I've been in discussion with your chair and the subcommittee chair for almost a year now, because it was about this time last year that we were rushed out the door, as you might recall, and your committee did not move favorably on this bill. Chair Pendergrass actually challenged me, and she gave me a homework assignment. And she asked me to look at Baltimore Community College and compare it to other community colleges. The bill is originally written, as you can see, compares it to universities. C is not a university, it's a community college. But it's different than all community colleges because it's a state agency and has been for several decades. It does not benefit from the CADE formula. It does not benefit from other community college capital money. It is in our state budget as a separate item. So I did exactly what the chair asked me to do. And I compared, I looked at 3-4 community colleges around the Baltimore area, and what I found was interesting. Presidents or their designee were able to do procurements of up from $75,000 to $80,000 to $100,000 without anyone's authority. They were able to, with their board or board of trustees permission, do procurements of up to several $1 million without going through the Board of Public Works. It just had to be budgeted in their budget. This is not true with BCCC. They go through a very long procurement process, including the Board of Public Works. So I am going to be presenting an amendment to this bill that helps BCCC fulfill its mission as a community college, but also puts guardrails around that. I'm going to do it so that they are much like other community colleges with up to $100,000 that can be procured without anyone else's authority, that the Board of Trustees can approve up to $500,000. And after that, they must go through the Board of Public Works. The bill as written includes capital. And rightfully so, the fiscal writers said that they didn't believe BCCC had the capacity to do capital, to build buildings, to so on and so forth. They don't, and they don't want it. So we will also in the amendments exclude capital, but we will leave in their ability to do maintenance and other kinds of work that might fall into a capital non-operating area of up to, again, $500,000. I have included with my testimony a long list showing you the kinds of impediments that BCCC has faced. You know, an example of an HVAC, it took several months to get it replaced by going through all the state procurement processes. Another one was a leaking hot water heater, where they literally had to close down the gym because it was $125,000 to replace, and they only have the ability to spend $50,000, and then it goes all the way through the Board of Estimates and the whole procedure. And I just will end with this. When the pandemic hit, every college, every university, every school in Maryland had to find a way to procure devices for their students and to help them with digital learning and to keep learning going as best as possible. The one school system, I will tell you, one school in this state that was hampered by that was BCCC. They could only spend up to $50,000. And then they had to get behind the health department, and they had to get behind every other department in the state of Maryland to do their procurement. So with that, I ask you to look at this amendment, and I hope you'll, as amended, pass this bill and also the Senate bill. The Senate sponsors work very hard on this bill. And I thank you.
Thank you, Madam Chair. I'm wondering if there are questions of the sponsor of the bill before I call the panel. Questions of Chairman McIntosh? Seeing none. Okay, we will call our panel, beginning with Dr. Deborah McCurdy.
Thank you so much, and good afternoon, Chair Pendergrass and Vice Chair and members of the committee. For the record, I'm Deborah McCurdy, president of Baltimore City Community College. I'm joined by several cabinet administrative staff at the college. Thank you for this opportunity to support the bill. On behalf of the college, let me thank Chairwoman McIntosh for bringing this legislation. I originally submitted the testimony several days ago, and then I spoke with Delegate McIntosh about the amendments that she has proposed as well. We are in full agreement with the amendments in the testimony that she has provided, which will offer us a tremendous amount of flexibility. And the legislation is important, allowing BCCC to be more responsive to our students while maintaining the high level of accountability that we need. It also puts us in better footing with our two-year school peers. They are able to do things administratively and with their boards as well. Many of you are aware that we are under legislative mandate to improve the college's operations, and task 11 under these mandates asked to identify barriers in state and local laws that impeded our ability to operate efficiently. The current procurement authority is a barrier, and then we can say a number of examples that you have, but we have a number of grants that fund equipment supplies for instructional programs. Because of the long procurement process, there are undue delays. We've had delays with some of our public safety equipment taking months to get through. With some of our larger grants, we've lost over $1 million over a 15-year period on one of our large grants. Our solicitation is at threat as well with the pandemic, with Comcast, as we tried to provide students with internet service. That took some time. We had to reduce the amount to $49,000, only serving 800 students. Our loan service and our financial aid services as well, trying to renegotiate these things takes a great deal of time. Well, you do have the list. I see my time is up, but understanding that there would be policies and procedures to govern our new procurement thresholds as well, that would go through our board, that would go through the General Assembly and the Board of Public Works as well. And at a time that we are making significant progress at our institution, the House bill, passing of House Bill 770 will provide really a vital operational tool to help deliver very differently for our students. And so for all of these reasons, we request a favorable vote on House Bill 770. And again, thanks to Delegate McIntosh and to this committee as we request a favorable vote. And thank you. We will be very happy to answer any questions.
Thank you, Dr. McCurdy. Chana Williams.
Good afternoon to all committee members and to the chair. Thank you, Madam President. My name is Shauna Williams. I'm the CFO for Baltimore City Public Schools. And I just want to reiterate some of the examples that Dr. McCurdy mentioned to give life to the story we're telling. So a lot of our equipment for our nursing program, it exceeds $50,000 a year. So while we're going through a procurement process that takes anywhere from 2 to 6 months, our students don't have that equipment and they're in our nursing program. We also have grants that fund a lot of this equipment, and we're not spending down the grants timely. And so we lose funds, which also impact the students. Dr. McCurdy also mentioned about Comcast. Once we procured laptops for our students, which took a significant amount of time, we then needed to provide internet service for our students. And because we could not expend over the threshold of $50,000 without going through multiple months, we only serviced 800 students, and we reduced the services that our students needed to stand up education requirements in a fully remote environment. We have thousands of students. So that was a significant impact. We also have grants for our refugee students, where we spend approximately $150,000, and due to the oversight process and how long it takes, those services are not extended to our refugee students in a timely manner. We've had several facilities challenges as well. The majority of our contracts are related to health and safety for larger maintenance items. Some of these items include elevators not working. We had one elevator go out in our building. It took us 6 to 7 months to get the elevator fixed. That's the only elevator that the facility has. And so we were out of ADA compliance. So it triggers an entire host of operational challenges for the college. And so I'm requesting Just as Dr. McCurdy noted, a favorable opinion of Bill 770. Thank you.
Thank you. Catherine Dixon.
Thank you. My name is Catherine Dixon, Assistant Vice President for Facilities. And just to reiterate what the President and Shauna Williams stated, passing this bill will become a much more efficient process in being able to address critical deferred maintenance issues that currently need to be sent through DGS or other processes that can create a delay in life safety related items. 95% of our deferred maintenance projects that are going to be funded in the capital budget are under 500,000. And these include important life safety items as fire alarms, elevators, HVAC, mechanical, other infrastructure, and roofing. We have several, roof leaks that really can't wait. So we need to be able to address these items to get caught up on our critical maintenance, replacements, and repairs without sending to a control agency, which will add delay, and we are increasing our experienced staff as well to be able to do this. Thank you.
Thank you. Dr. Liesl Jones.
Hi, good afternoon. I'm Dr. Liesl Jones. I'm the Vice President for Academic Affairs at Baltimore City Community College. And so I thought I would give a different example, which is the Perkins Grant. Every community college has access to the Perkins Grant. The grant's funded, the money shows up in October. If we have a piece of equipment, and we actually have 3 pieces of equipment currently that we have yet to be able to purchase, and it's now March. Those bid started in November and December. The next grant where we have to provide the outcomes for the current grant is due in May. It's very difficult for us to continue to provide outcomes off of a grant when we can't actually purchase the equipment which we need for the courses to do the work to provide those outcomes. Having this bill passed would allow us to use the Perkins money as soon as it hits our accounts, and would provide that equipment and those tools for instruction immediately to the students, and would allow us to really make an impact upon our students' lives. And so for the instruction side, it's imperative that we get this passed. It hampers us in so many ways. I personally would like to buy 3D anatomy tables for our nursing program and our biology program. One of those tables alone is above our procurement level, and we need 3. So these are just examples of the ways in which we need to move innovation forward and better engage our students. But by not being able to purchase in a timely fashion, it's very difficult for us to make those changes and to better our students' lives. So thank you for your time.
Thank you. Thank you all very much for your testimony. Questions for this panel. Delegate Bandari.
Yeah, thank you, Madam Chair. Thank you, Chair McIntosh, for a wonderful bill. I had an opportunity to serve as an adjunct faculty at that community college for 5 years. I understand the issues. Thank you so much for this bill. And looking through the testimony, there is a testimony in opposition from International Brother Electrical Local 24. And it says that if this is enacted into law, it would exempt workers from Maryland State prevailing wage laws. Either President or Ms. Jones, you wanna touch up on that?
Yes, I'm not certain about the wording there, but if you're talking about a living wage, we meet both the living wage as well as the prevailing wage requirements. We work with the state of Maryland, and so, and certainly going through DGS on any of our major projects that we would be meeting these requirements.
Okay,
thank you.
Thank you. Delegate Krebs.
Thank you, Madam Chair. And thank you all for giving us very specific examples of why you need the bill, and you made your case. But in
note, it said that you may likely need additional procurement and technical staff to carry out these responsibilities, but they couldn't get a reliable estimate because they had reached out and didn't get any information back. So do you all have the ability to be able to do these procurements with this current staff that you have? Is that going to be problematic?
When I first joined the college a little under 2 years ago, we had 3 individuals in procurement. We now have 5. A 5th one is joining us, if I'm correct, Ms. Williams, next week or on the 24th. So we have a new procurement director coming in fact, coming in from one of the state agencies. So we have deliberately changed our staffing directions at the institution to begin to partner more closely with the state in seeking, if you want to say even poaching individuals from state agencies to join us in the ventures that we have at Baltimore City Community College. So we're very pleased. We now have 5 people on procurement and that will assist. On the facility side, we know we've already begun those discussions and had some earlier today that we will begin to revamp our facility staff as well as we look at bringing in more professional staff on that side of the house as well. And remember, on the larger projects, we still will be relying on DGS and their expertise as well. So we're not trying to marshal all of this through. That would take a full facility crew, much like you would see at one of the larger institutions.
Thank you. Got you. Thank you very much.
Thank you. Are there any other questions from the committee? Seeing no hands, that concludes the hearing on HB 770. Thank you very much, Chairman McIntosh and the panel for your time and testimony today. We'll move to the next bill, which is HB 1150. This is sponsored by Delegate Cox. It's Health Authority of the Secretary of Health and Medical Information. The delegate's testimony is going to be presented by his assistant, and that's Dan McHugh. Mr. McHugh.
Oh, thank you, Delegate. I'm sorry. Can you hear me?
Yes, we can. Now we can.
Okay. Thank you, Delegate and Chairwoman Pendergrass and Vice Chair Melnick. I appreciate the opportunity today to speak before this committee on an important piece of legislation, HB 1150. It has to do with rights of the individual. We urge a favorable for 1150, which would, in time of emergency, alter the law that prohibits a parent or guardian from being required to present a certain certificate of immunization under certain circumstances to be admitted to school, apply for public school, requiring the secretary, include individuals while exercising certain authority and prohibiting individuals from being required to provide a proof of medical examination, vaccination, medical test, or any other medical information to obtain employment or travel by air or otherwise. We are submitting emails from people all over Maryland who are concerned about the government's overreach during times of emergency, as well as a study conducted by Dr. Jay Bhattacharya of Stanford University. As much as government needs to reasonably respond to an emergency, government needs to be restrained from overreaching into decisions best left to the individual. It is the individual that will make the best choices for themselves, their families, and our communities, particularly during a health emergency. Let's not put more obstacles in the way of individual freedoms. I urge the committee to support the rights of individuals to be able to go to school, gain employment, and travel without having to submit more government mandated programs. We ask the committee for a favorable, and we thank you for your time, committee, and happy to answer any questions. Thank you.
Thank you, Mr. McHugh, for standing in today for Delegate Cox. We'll give the remainder of your time to Mr. Adam Reuter. I apologize if I've not said your name correctly.
Hello, can everyone hear me?
Yes, we can.
Okay, great. Sorry, I was actually still preparing, but I'll do my best. Okay, my name is Adam Reuter, and I'm the founder of the Maryland Deserves Better campaign. I am in full support of House Bill 1150 for the year 2021. It must be approved to protect Maryland citizens' safety. Currently, the Food and Drug Administration has not fully approved any COVID-19 vaccine. They are all authorized for emergency use only. The normal vaccine testing and approval process requires animal studies and years of rigorous long-term human trials. This is not the case for EUA vaccines. I'm not anti-vaccine and am personally caught up on all my vaccines except the flu vaccines, but I am very cautious about experimental drugs being given to people without long-term studies. The COVID-19 vaccines are possibly dangerous, and requiring them in order to regain freedoms that was previously afforded to everyone shall be outlawed. Adverse reactions to COVID-19 vaccines have already occurred, including death and miscarriage. As of March 14, 2021, there have been 30,938 adverse events, and of those, 1,394 are deaths. This is according to the Vaccine Adverse Event Reporting System that's available to look at vaers.hhs.gov. It should be noted that the majority of these COVID-19 vaccines are of the mRNA type, and they've not been used widespread until this past year. And it's possible that antibody-dependent enhancement issues will arise at some time in the future. Possible. I personally hope that does not happen, but it is a possibility. And if that does happen, there could be severe consequences to Marylanders' public safety and health. So just to wrap this up quicker, there's actually early COVID-19 treatment options that are out there. One's Math Plus, the other one is iMask Plus, and these also can be used as prophylactics, and information about those can be found at covid19criticalcare.com. And also niacin is something that's being researched early, so that it would basically make these emergency use vaccines unnecessary. So to wrap that up, I hope that the committee members here give House Bill 1150 a favorable support and approve it to move forward. And if you want to research even further about this, please look at videos and read articles featuring Dr. Richard Urso. His last name is spelled U-R-S-O. Dr. Pierre Corey, his last name spelled K-O-R-Y. And finally, Dr. Sherry Tenpenny. Thank you, committee.
Thank you very much. Anna Poland?
Fortunately, Anna's not going to be with us today.
Okay. Vince McAvoy?
Thank you so much, Chair and committee. I appreciate you hearing me on this. I had introduced a large written testimony with this, about 17 pages, and I really want to defer mostly to that. But I do thank Delegate Cox for bringing this bill. We have an issue now where we have an experimental vaccine, several of them, that are being used, and we're having a lot of kickback on those. We've received over 1,000 deaths nationwide. We have 20-some countries, 10 I believe in Europe, who have rejected one of the 3 that are out there. So when we're looking at a type of mandate for travel, for getting into entry to buildings and other type things for airline travel, to mandate this at this early stage is oppressive. And now this is actually happening very close to us in New York City. They have an experimental app that they're running. They're declining to give entry. And this is going to create a multi-tier system. There could be people that have objections. I do know of someone who actually 2 days after getting shot is in ICU now. That's in Baltimore. So it's very close to home. And so people could have personal objections. And frankly, we don't do this. We have a very short list of vaccines that are mandated. And so what Delegate Cox's bill is doing is simply to make it so that our personal liberties, our personal freedoms are not impinged by being caught up in science that is not, it's not very much. A year is what we're looking at. And so that's why I would point you to page 8 of my written testimony, where it talks about charts that CNN forgot to show. This is by Tom Woods. And the hope that I present that is that there are those amongst you that may not have seen all the data out there, and that this gives you a fresh perspective. I thank you so much for your time and listening.
Thank you, Mr. McAvoy, and we will check out your written testimony.
Grateful, thank you.
As well. Any questions from the committee? Okay.
Chair, sorry, Ms. Pollen is here now.
Oh, I'm sorry. Thank you very much. Ms. Pollen? Perhaps you're on mute? Do you see her, Melissa?
Yeah, she might be on an iPad. She needs to unmute herself.
Okay. Ms. Pollen, please unmute yourself. Well, let me see if, let's give the committee a chance to see if there are any questions. Maybe. Ms. Pollen, here we go. I see you're connecting now. Good. This is the challenge of the new technology. It looks like there's a little bit of struggle in the connection. Okay. Ms. Pollen, I'm afraid your connection may not be strong enough for you to connect to us. And we do have a timeline today that we need to meet. So I think we are going to have to move ahead with the next bill. I apologize for that. Seeing no questions from the committee, that concludes the hearing on 1150. And thank you to Mr. McHugh for testifying for the delegate and the those who came to testify today. We appreciate your time and testimony. And that moves us to Bill 1156. Delegate Metzger, welcome back.
Well, hello there.
This is Commission on Men and Fatherhood.
Yes.
Act. Delegate Metzger, so good to see you.
Yeah, let me flick my switch on there.
Okay, we hear you, but we don't see. There we go.
There you go. Well, good afternoon, ladies and gentlemen. House Bill 1156, if they see this. House Bill 1156, Commission on Men and Fatherhood, March 17, 2021. Happy St. Patrick's Day. I got my green tie on. Madam Chair and of course, Madam Vice Chair. And by the way, Delegate Cullison, we haven't got our selfie yet, so we've got to make sure we take time for that.
Indeed, indeed.
For the record, I'm Delegate Rick Metzger from Legislative District 6 in Baltimore County. Thank you for the opportunity to speak to you today. It's always great to be amongst friends and colleagues. The purpose of this bill today, which is cross-filed by Senate Bill 807, which is to establish a state commission on men and fatherhood under the Department of Human Services. I must say that this is a unique bill and an opportunity for a real commission to really study process of men and their qualities and they walk into court sometime and even though they don't have an attorney, they might have an attorney and they just don't understand the rights. So this gives an opportunity, consists of 25 members appointed by the governor
from geographic diversity of the four-year term, which interests relate to the status of men. The commission shall meet at least 6 times a year annually, vote for a chair, vice chair. The Secretary of Human Services and the Secretary of Health may participate in the commission as ex officio non-voting members. An executive director shall be a merit employee, but members of the commission may not receive compensation except for reimbursement for the standards of state travel and regulations by the state budget. This commission is long overdue for men and fathers and their issues. And I might say that this is an opportunity for people to really come together and mentor, share ideas, share thoughts on mentorship. And I respectfully request a favorable report on House Bill 1156. And thank you for your time and consideration. You've got several people that's going to testify in favor. And of course, there's always the opposition, but we'll welcome the dialogue and look for a great outcome. God bless you. And I'm going to get back over here and vote for just a second.
Okay. Thank you, Delegate. Mr. Vince McAvoy.
All right. Thank you so much, Chair, Committee, and most especially thank you, Delegate Metzger, Chief of Staff Paul, for taking this brave step to help Maryland's fathers, its children, its future. Studies detailing the damage from the loss of biological fathers are irrefutable. America's great social experiment beginning in the 60s has yielded its disappointing, damning fruit. The Revs bill aims to reverse this attack on fatherhood in Maryland. This commission will detail areas and reasons why biological fathers aren't engaged in their children's lives. The commission will review the results of divorce court and family law code. Their mothers receive sole custody 6 out of 7 times, despite law and evidence, which would indicate a different ruling from the bench. Why is that? Commission data will be folded into policy efforts to lessen the economic, societal, and relationship impact of family separation. We'll communicate strategies, we'll develop success right away, we'll reduce stress, ensure positive, holistic outcomes, save taxpayer dollars, and support fatherhood at this critical time. Our state policies attack fathers. When our fathers suffer, our children and our families suffer. When fathers are encouraged, their successes, more than those of any other person in a child's life, translate into success for Maryland's children. For the record, a reminder that my written testimony on HB 1156 and SB 807 details Maryland senators and Maryland delegates affirming this bias against fathers, this hate of fatherhood, this attack on fathers and men. Their words, their Annapolis hearing room testimony. So my aim in urging Delegate Metzger to bring this bill is to produce prioritized focus, simple solutions, and eliminate guesswork by applying root cause analysis on fatherhood issues. I remain available for questions. I encourage a favorable on this. Thank you so much. And thank you, Delegate Cullison. Thank you.
Thank you for your testimony. Are there any questions for this panel? For the sponsor? Any questions? Seeing none, then the delegate referred to unfavorable. So we have Kathleen Hoke, who is going to speak to us today.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. I'm Kathleen Hoke, a resident from District 11, here today in opposition to House Bill 1156. When the General Assembly created the Commission on Women in 1971, we were faced with the circumstance where women were woefully underrepresented in industry, in elected office, and in recognition. While we've made progress, and today's committee makeup tells us that we've made progress, and we certainly still need the Commission on Women to reinforce the efforts there. Those same justifications do not underlie the Commission on Men proposed in this bill today, and I'll use 2 points in the bill to make that clear. First, the bill would mandate that the Commission encourage men to seek elected office. With women comprising 52% of the population in Maryland, we have never had a female governor, comptroller, or attorney general, the 3 statewide elected offices. Currently, Maryland has no female representation in Congress, and we've only ever had 1 U.S. Senator, the indomitable Barbara Mikulski, in our history. While this House reveals improving representation of women at 42%, your colleagues across the street in the Senate are quite lacking at 32% of women membership. Here you have, of course, the first female Speaker of the House. We have never had a female President of the Senate. So there is no evidence that we need to encourage men to run for office in Maryland. Quite the contrary. The bill also mandates that the commission secure appropriate recognition of men's contributions to the state. And again, evidence is to the contrary with respect to the need for this. If we were in person, I would point out that we were having this hearing in the Kaz Taylor House building adjacent to the William James Senate Office building, or I'm sorry, the Thomas Lowe House Office building. Last week, I was in the Mike Miller Senate building adjacent to the William James Senate building. We could travel up Thomas Bladen Street to the Louis Goldstein Treasury building, a little farther up Roscoe Rowell Boulevard to the Robert Murphy Courts of Appeal building, adjacent to the Millard Tawes office building, and across the street from the Sweeney Courthouse. I think I've made my point here. Men are not underrepresented for their recognition. And while the Commission on Women should still stand, there is simply no justification. And for these reasons, I urge an unfavorable report on House Bill 1156. Thank you.
Thank you. Questions for Ms. Hoke? I see Delegate Kelly. Up, unmute, Delegate.
Sorry, just a question for Ms. Hoke. You seem awesome. Can we be friends?
Yes.
Okay,
cool. We are, apparently.
Thank you for your testimony.
We're both wearing the green, Ms. Kelly. I mean, Delegate Kelly. So there you go.
But in all seriousness, I appreciate you raising those points about sort of all the men surrounding us and the male names. I think it's really important that we keep reminding ourselves of that, because here in the House, we are doing so much better. Even in the 11 years I've been here, it's been amazing, and we want to see more progress in that direction.
Thank you. And I should say, I'm saying this for my daughters, for my granddaughters, and for those that belong to you as well.
Thank you.
Thank you. Delegate Krebs.
Thank you, Madam Chair. And I'm just reading the bill, but the one thing that I looked at the title, and it's more about Fatherhood Protection Act, but the one thing that really does compel me in here, some of it I agree with and some of it I don't, but there's one part that really I agree with: strengthening home life by directing attention to critical problems confronting men as husbands, fathers, and homemakers. I mean, breakdown of the family, many times, it's usually the man that's left is involved with some of these problems. And it seems like there needs to be some energy focused on men and how to make them better husbands, better fathers, better whatever. And I think this seems broad to have there's a lot of things the commission has to look at, but I don't know if there's any common ground with acknowledging that the breakdown of the family, usually it's the women, the mothers that are sort of stuck with taking care of everything. And how do we encourage being good husbands, good fathers, and everybody working together? I think there's something to be said for that in some way. So take that part for what it's worth. And I'm not sure if there's any common ground. I was going to ask, I'm trying to figure out who's on here left. The one, Mrs. Hoke. I mean, would you agree that maybe on that particular item, there might be some opportunity for focusing on some of the problems that are undermining our families and parents, specifically the men in the family?
So I dare say it's your prerogative to determine what is appropriate for legislation. I think this bill does far more than that one element in it, and so for that reason I'm opposed. I will say, looking at who's providing the care in the home, we know that the pandemic has had a disproportionate effect on women. Our burden at home has eclipsed what it was before, and has had an impact on our ability to maintain employment, maintain full-time employment. And so the pandemic has only made the situation worse for women, to the extent that there is a need to support families of all sorts, whether it's two moms or two dads, or one mom or one dad, or what have you. I strongly encourage whatever the legislature can do to help build and strengthen family bonds. And I do believe that there are agencies, including the Department of Social Services. I love the bill I heard earlier about foster parenting for LGBTQ+ children, and the Maryland Department of Health, other agencies that are working in this space. And so maybe collaborating with those agencies and seeing what they're doing would be a great first step.
All right, thank you.
Thank you. Delegate Slaga.
Thank you. And this question would be for Kathleen as well. Thank you for being here. And while I agree with you on the run for office mission of the commission, which can easily be amended out. I'm sure Delegate Metzger would be fine with that. He probably took the language directly from the Commission on Women, is what I'm guessing, and substituted fatherhood. But do you think there'd be value in a commission that really looked at promoting fatherhood and the challenges of fatherlessness that are plaguing some areas of our state?
So again, as I said earlier, I think the prerogative of what belongs in legislation is up to this body. This bill just does so much more than that. And the justification for the Commission on Women, after which this bill was modeled, simply doesn't exist for men across the board. There is already work being done in, and again, enhancing family connections, and whether it is, work needs to be done in increasing fathers' involvement in children's lives, or increasing ways that can allow women to have more involvement in their children's lives when they're working 2 jobs and trying to maintain the family. I'm all for supporting the family structure in whatever form it may take.
Yeah, and fathers, I think I would just mention, have had as equal amount of the responsibility over COVID. I've seen men, single fathers, and others really struggling. So I don't think it's fair to men to insinuate that women are carrying all the load here. So thank you.
Thank you, Delegate. Seeing no further questions, thank you, Delegate, for bringing us the bill. And for those who came to provide testimony, thank you for your time today. That concludes the hearing on 1156 and the work before us today. I would remind the committee that the floor goes back into session at 4:30 today. And please watch the schedule and your emails for rapid changes in the schedule. I wondered, Chairman Pendergrass, if you had any announcements you'd like to make regarding the schedule.
I don't think she's with us right now.
I don't think so either. Okay.
But we will have a
Vice Chair Peña-Melnick.
Yes, the Public Health Committee will be meeting tomorrow at 8 in the morning. The link and the required material for the meeting has been sent to committee members and to the advocates and interested parties tomorrow morning at 8 o'clock in the morning. I don't know if Melissa had any additional messages.
Yeah, the chair just wanted to remind everyone that we'll have a voting session immediately after the floor this evening.
Okay. With that,
do we have the voting list if we're voting right after session?
I'm about to send it out. Yeah.
Okay. With that, thank you all very much. This concludes the hearing for today, and have a good